Chevron Deference, the end of a legal era. In our last lesson, we explored the 5 primary sources of American law: the Constitution, statutes passed by Congress, administrative regulations, judicial decisions, and executive actions. But what happens when those sources overlap or conflict? What happens when Congress passes a law that isn't completely clear? Who gets the final say, the courts or federal agencies? For nearly 40 years, the answer was often federal agencies. But in 2024, the United States Supreme Court changed that rule. Today, we're looking at one of the biggest developments in modern administrative law, the end of Chevron Deference. To understand this change, we need to go back to 1984. That year, the Supreme Court decided Chevron versus Natural Resources Defense Council. The case involved environmental regulations and the interpretation of the Clean Air Act. The court faced an important question. When Congress writes an ambiguous law, who should decide what it means? The answer became known as Chevron Deference. Under this doctrine, courts followed a simple 2-step test. First, judges asked whether Congress had clearly addressed the issue. If the law was clear, the court followed it. But if the law was ambiguous, the court moved to step 2. Was the agency's interpretation reasonable? If it was reasonable, courts generally deferred to the agency. This doctrine gave federal agencies significant power to interpret and apply laws. Supporters argued that this approach made sense. Agencies employ experts in specialized fields such as environmental science, healthcare, finance, and telecommunications. Because agencies possess technical expertise, many believed they were better equipped than judges to handle complex regulatory questions. Supporters also argued that Chevron promoted consistency by allowing agencies to establish nationwide standards, instead of leaving interpretation to different courts. For decades, Chevron shaped how the federal government operated. However, the doctrine also faced criticism. Many legal scholars and judges argued that courts were giving away too much of their responsibility to interpret the law. Others believed Chevron gave excessive power to unelected agency officials, allowing them to influence policy through their interpretations of statutes. As these concerns grew, the Supreme Court became increasingly skeptical of the doctrine. Then came the case that changed everything. In June 2024, the Supreme Court decided Loper Bright Enterprises versus Raimondo. Although the dispute involved federal fishing regulations, the court used the case to reconsider Chevron itself. In a 6-3 decision, the court formally overruled Chevron Deference. The court held that judges must independently interpret federal statutes. While courts may still consider an agency's expertise, they are no longer required to defer simply because a law is ambiguous. In other words, federal judges now have the final say on what federal laws mean. The impact is significant. Courts will play a much larger role in resolving disputes over regulations. Federal agencies will face greater scrutiny and more legal challenges. Lawyers will place greater emphasis on statutory language because courts will focus closely on the actual text passed by Congress. The decision may also encourage Congress to draft laws more clearly, reducing ambiguity and limiting the need for agency interpretation. Supporters of the ruling argue that it restores the judiciary's constitutional role and strengthens the separation of powers. Critics warn that it could increase litigation, create uncertainty, and make it harder for agencies to respond to complex policy issues. Regardless of where you stand in the debate, one thing is clear. The Chevron era has ended. For nearly 40 years, agencies played a major role in interpreting federal laws. Today, that responsibility has shifted back to the courts, and that shift will shape American administrative law for years to come. Thanks for watching, and I'll see you in the next lesson.